sir.
Okay. And that is your true and correct name?
Yes, sir.
And let's see, your date of birth is 7/19 of 1990.
Yes, Your Honor.
And you recognize your attorney, Mr. Morales?
Yes, Your Honor.
And Mr. Morales, you recognize your client, Mr. Armendariz?
Yes, Judge.
Okay. Now, I think the cause number is 2018 0D00343. That is the one we're proceeding on?
I think there's a 2017 case that he's also pleading on, Your Honor.
2017 0D06639?
Yes.
Is that correct?
I think there should be paperwork on both cases, Judge.
Yes, I've got them. These are both pleas of true? Yes. These are not new charges. All right. So, if I guess Ms. Espinosa, if you would like to state the plea agreement on the record.
Yes, Your Honor. On the 2017 case, it's to 2 TDC. And on the 2018 case, it's 6 months state jail.
The 2017 case, it's 2 TDC, and on the 2018 case, it's 6 months state jail,
Yes, Your Honor.
and they run concurrent.
Yes, correct.
And of course, we'll give him credit for all the time that he has served. That we're allowed to under the law. Okay. Is that your understanding of the plea agreement, Mr. Morales?
That is my understanding, Judge.
Okay. Is that also your understanding of the plea agreement, Mr. Armendariz?
Yes.
Now, you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your pleas and we could proceed to a full hearing on the motions to revoke. You understand that? Do you understand that?
Yes.
Okay. Now, we have in front of us some documents marked States Exhibits, I believe, 1, 2, and 3. The stipulation and waiver forms in this case, they bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, sir.
Did you read them before you signed them?
Yes, I only have one question.
Yes. Okay. What is your question, sir?
How much is my time served right now? How much is my time counting for jail time?
Okay.
much-
Yes. You want to know how much time credit you have, correct?
Yes. Yes.
Okay. Let me ask the clerk. She's the one that has that number.
Yes, Judge, I have it. On the 2018 case, he has 461 days.
400, the 2018 case.
Yes,
He's got how much?
461.
Okay, well, that would be, since it's only a 6 months, that's already served, right?
Yes, Judge.
Okay, and then on the 2017 case, how much time does he have?
He has 333 days.
333. So he's got roughly half of that amount of time served. It's a 2-year sentence.
Mhm.
Of course, you're eligible for parole after serving, what is it, on that kind of an offense? I'm not sure, but it seems like you might not serve a real long time on that one either. I don't know. Because that's up to the parole officials, and you've got so much time credited there that you might, I don't know if they'll even want to transfer you down there. I don't control that. Okay. Does that sound like what you thought you had?
Yes, so my deal is like, I still have like 360 something days to serve.
It would be somewhere around, well, I don't know if you'd actually serve all of those days. On the one sentence, that state jail, it doesn't look like you're ever going to go over to the state jail, to me. Does that sound right, Mr. Morales?
It does, and Mr. Armendariz, if you remember, we spoke about this last night. The court can sentence you, but the judge doesn't have any specific authority about how much time you're going to serve. TDC will do those calculations. We definitely talked about this last night.
But like I said, what they can do is, I mean, they can do all kinds of things, you know, like if they think you've served enough time, they can tell the people here at the county jail to just release you. Or they can say, bring him down here for a little while, we'll have him serve some time. And then that depends on how you're behaving. It looks like you're wearing the green uniform, which means you've been a good prisoner, you know, because that means you're a trustee. So that, I mean, I'm just guessing, that indicates that they haven't had trouble with you. And of
Yes.
course, that's one of the things that they could make you serve more time if they have trouble with you. But if they don't have trouble with you, sometimes they make you serve less time. So that's all I can really tell you on that. I can't actually tell you, you know, exactly what they're going to do in your case.
So I have to wait for the answer on TDC?
Yes. Well, what will happen is, you know, once we process this paperwork,
Yeah.
the jail will send that to the Texas Department of Corrections. The TDC will then tell the jail, okay, we're going to ship him down to TDC when we come out and pick up people. Or they might tell them, no, we're not even going to bother to do that. He served enough time. I don't know. That's probably the least likely thing to occur. You will go down there, you will serve some time. If you do well, you probably won't serve all of it. Okay, would be my guess. But like I said, I'm not making promises there.
So the answer is for them? I'm
What?
waiting. The answer is, they have the answer for the sentence?
They will ultimately determine when to release you. They cannot hold you beyond the 2 years, no matter what. Okay, that they cannot do.
So I'm just gonna serve like about 367 years is the most.
You mean 267 days? You mean, well, you've served 300 and some odd on that one. So, and I don't know if he's entitled to more time on that one than that or not. It depends on the date of the offense on the 2017 case, but you have at least, what did you say? How many days did you say he had? 300 and something? Or
333 days.
333 days. So you've got almost a whole year in.
Okay.
So that, and you'll get credit for all of that. But that's all I can tell you. Okay?
Okay.
But you understand that this plea agreement's not absolutely binding upon me. But if I choose not to follow it, if I was going to be harsher than that or give you more, you could withdraw your plea and we could proceed to a motion to revoke. But if I follow the plea agreement, it is final. You can't appeal the case. You can't withdraw your pleas without my consent. Do you understand that?
Yes.
Okay. Now, like I said, we have these documents, these state's exhibits 1, 2, and 3, the stipulation waiver forms bearing the signature of your attorney, the state's attorney, what appears to be your signature. You said you did sign them. You did read them. Did you understand what it was that you were reading?
Yes, sir.
And did your attorney further explain to you the meaning of the documents?
Yes, sir.
And did you understand what he was telling you?
Yes, sir.
Okay. And so that there's never any question, let me briefly tell you what those documents mean. First of all, a stipulation is merely an agreement between yourself, the state's attorney, and your attorney that certain facts are true, such as you were on probation for certain offenses. And then secondly, you didn't abide by all of the conditions of your probation. You didn't do everything you were supposed to do. You violated that probation in some way. And then the waiver form tells me you're giving up the right to fully contest those matters in front of me, where the state would have to prove by a preponderance of the evidence. In other words, it's more likely than not that you had in fact violated your probation. You understand that?
Yes.
Okay, then how do you plead to each of these motions are they to revoke or adjudicate? Let me look. Were they deferred? Straight. Looks like
Adjudicate, Judge.
looks like deferred. Then how do you plead to these motions to adjudicate true or not true?
True.
Are you entering your pleas of true freely and voluntarily?
Yes, sir.
Did anybody force you, threaten you, coerce you, or in any way make you plead true?
No, sir.
Did anybody promise you anything or persuade you in such a manner you felt you had to plead true, other than the plea agreement stated on the record in open court here this afternoon?
No, sir.
Now you understand the potential punishment here. The state jail would have been from 6 months to 2 years in the state jail. The other case, was that a second or a third degree felony? The 2017
It's a third degree, Your Honor.
case. So that punishment would be not less than 2 years, nor more than 10 years to serve in prison. You understand I have to send you somewhere within those general guidelines.
Okay, so my question is no, nothing, I'm good.
Okay, yeah. What they're doing is I would have to send you somewhere within those guidelines, but the recommendation is for the very minimum. They have
Yeah.
recommended the 2 years and the 6 months, minimum on both cases. You understand?
Yes, sir.
Okay.
Yes, sir.
All right. Let's see. Are you a U.S. citizen?
Yes, sir.
How old are you?
I'm 32.
And how far did you go in school?
I did finish high school.
All right. So you can certainly read and write the English language.
Yes.
Have you ever been under the care of a psychiatrist or psychologist for mental health or mental illness issues?
No, sir.
Suffered any serious head injuries?
No, sir.
And are you presently under any medications for mental health, mental illness issues?
No, sir.
And so you're telling me you are mentally competent, you understand everything that's going on here this afternoon.
Yes, sir.
And counsel, you've had time to go over the facts and circumstances of these cases, the legal aspects of the cases, and had time to evaluate your client's mental status. Whoops, you're on mute.
I'm sorry.
I have, Judge.
Okay, he was on mute. I couldn't hear him. Okay, and based on all that, are you also representing to me that you believe your client is mentally competent to enter these pleas?
I believe he's mentally competent to enter the plea, Judge.
Right. And based on your recommendations, Mr. Morales, your representations, Mr. Armendariz, the court's observations of you in court, both here today and prior occasions, I find that you're competent to enter the pleas. State may summarize the evidence.
Yes, Your Honor, had the state proceeded to a revocation hearing, the state would have proven beyond the preponderance of the evidence that on August 16, 2018, the defendant pled under 2017-0D06693 and 2018-0D00343 to 5 years deferred probation. Thereafter, he violated his probation between the months of July 2021 and March 2022 by failing to report to the El Paso Community Supervision and Corrections Department, failing to pay his monthly supervision fee, failed to pay a $500 fine and court costs, failed to complete 100 hours of community supervision, failed to submit to breath analysis or urine analysis, and failed to attend anger management treatment. The state moves to introduce state's exhibits 1 through 2, which are the stipulations and waivers, and the trial court certification of the defendant's right to appeal.
No objection to their introduction, Judge.
All right. Received. Based on the evidence before the court finds the evidence sufficient to find the allegations true. I find them true. I therefore revoke the defendant's deferred status. I find him guilty in both of those cases, and I'm now ready to proceed upon the issue of punishment. Now, let's see. When you get out of prison, which will hopefully be in not the too distant future, what is your plan, sir? Do you plan to come back to El Paso, live here, family, work? What do you hope to do?
I want to come back to here to Paso right here to start working again.
And I know you worked at a restaurant before. And do you think you can, what kind of work do you think you can get?
Line cook in the restaurants.
You're a cook?
Yes, sir.
Okay. And then where will you live? Do you have some family that will put you up?
Yeah, my dad and my mom.
Okay. So you live with your mom and dad. What's given you a problem over the years, it appears, is some drug issues. I don't know if you've had a chance for any drug rehabilitation. They do have programs in both the prison and the jail under to try to help you and give you some treatment. There's also what we call AA or NA. If you get out, and I think those are free services, you might try to use those if you can find those helpful. So with that, I will follow the recommendation, and it'll be 6 months on the state jail, the minimum, and 2 years in prison on the other case, which is also the minimum. And good luck to you, sir.
Thank you.
Thank you.
Thank you very much, Judge.
All right. Now, if we could proceed with Mr. Garcia.
I think we have a problem, Judge. we mistakenly thought that the plea papers had been submitted by Mr. Rosales and they had not.
Well, that's not good. Well, we can't proceed without they haven't signed them. Well, that's going to be disappointing, so we'll have to wait. I hate to break that bad news to him. Okay, Mr. Garcia.
Your Honor.
Okay, I have some not the best of news here. Apparently, I thought that your attorney, Mr. Rosales, had brought you the plea papers and he had gone over them with you and signed them. And apparently that did not happen yet. Okay, we have to have that done before we can proceed, but I feel bad that you are going to be delayed because we cannot do that without those papers signed. But what I will do is as kind of hopefully a benefit to you, is we will get a hold of Mr. Rosales, we will get those papers signed, and instead of waiting until next Thursday to do this, I will try to bring you down from the jail to here, to the court, so that we can do it in open court, maybe Monday or at the latest Tuesday. But I do want those papers signed, because if that's what you want to do, if you want to resolve these cases and you're willing to do that, then, you know, I want to accommodate you and get that done. Because I know you've been in jail for, you know, a number of days.
Yes, Your Honor.
Okay, so we will get a hold of Mr. Rosales to get him to go out to the jail to get that done either tomorrow or over the weekend, and then get you back here Monday or Tuesday. Okay? Thank you. I'm sorry we couldn't proceed further.
Okay. Thank you, Your Honor.
Thank you. All right, someone needs to get a hold of Mr. Rosales then and tell him he's got to get the plea papers in, and we'll have to get that done in next week. So, all right, how about Mr. Campos?
Right up, Your Honor.
What is the plea agreement on this case?
It's 10 years deferred probation, Your Honor, on the charges is, and no contact with the complaining witness.
Have you been in contact with the complainant on this?
I personally spoke with him, Judge, yes.
And he is satisfied with this resolution?
Yes, he is. He did not want to give a victim impact statement, but he does ask that no contact with his shop or with himself be honored.
Okay. All right, I want to be sure.
Yes.
All
and
right.
From what I understand, there should be like, I guess Mr. Caballero has made sure that Mr. Campos is on his medication and.
All right.
Yes, that's right.
Okay, well
He
then
was
let's,
incompetent judge since
Yes,
when
for
he was
quite a while.
arrested.
right, he's been incarcerated for quite a long time,
Yes, Judge.
like almost 3 years. So I mean, he's gotten a lot of time,
Yes.
mostly to regain his competency. So
Yes,
he's
Judge.
just been recently found competent, so now we can resolve the case. Okay, this is cause number 2020-0D05304. The state of Texas versus Ramon Campos, present in court. And is that your true and correct name, sir?
Yes, Your Honor.
And let's see, also known as, also is possibly Villalobos.
Yes, Your Honor. That's
Okay.
fine.
And is your date of birth 1/20 of 1975?
Yes, Your Honor.
And do you recognize Mr. Caballero? I think mostly you've dealt with Mr. Vargas, but do you recognize, if Mr. Caballero, have you ever dealt with Mr. Campos?
Yes, I have, Your Honor.
Okay.
Mr. Vargas and I have been working on the case together.
Okay, so you recognize Mr. Caballero then, Mr. Campos? And Mr. Caballero, you recognize your client, Mr. Campos?
Yes, Judge.
Okay. And then Ms. Espinosa, if you would state again the plea agreement, please?
Yes, Your Honor, it's 10 years deferred probation. However, Judge, I'm not sure if Mr. Campos currently has a place to reside. I wanted to make sure that there was a bed space for him before he was released.
Yes, have you worked on that, Mr. Caballero, where to release Mr. Campos to?
Yes, Judge. He's been referred to reentry, and we're waiting to see, but he's going to go to more than likely the rescue mission. We were trying to find something better than that, but as of right now, the number he provided to his niece wasn't working. It just hung up.
Okay. Well, then, I mean, it's got to state on the sentencing form that he be released to the personnel from the rescue mission. They have to take him to the rescue mission then. I don't want him just out on the streets, you know, because the annex is a long way from downtown El Paso.
Yes, Judge.
Now, if you find a place where he can stay with his niece and she wants him staying there, that's fine. I can have him, I'll allow him to reside there. But I think Ms. Espinosa has a very valid concern. We want to make sure that he has a place to reside and that he's going to then, of course, that it takes his medications.
Yes, Judge. At this time, I understand the court's concern. At this time, I can't guarantee or provide with a certain degree of definiteness that he's going to go to a specific location. If the court wishes, we could reset the matter.
Yeah, I think I'd rather reset it without knowing exactly. I don't want to do that until I know he's got a for sure place. I just don't, you know, like this morning, he would have, if we would have released him yesterday, he'd have been standing out there in the snow.
Yes,
you know,
Judge.
with nowhere to go, and that would not have been good for him nor the community.
Yes, Judge.
Okay, so maybe, Mr. Campos, we're going to resolve your case. There isn't a problem with that. It's just where you can stay, and they haven't got it firmed up yet. Yes, sir.
I was referring me to go to UPH to get help.
Right, but they're not, UBH, I don't know, is not like a permanent residential facility. It is they do have a component where they have inpatient, I believe, but I don't know if that's, I don't think that's the route you're discussing. Was it, Mr. Caballero?
No, Judge. I think he's probably talking about his mental health. Mr. Campos, I'll go see you tomorrow. Okay. I'll visit you at the annex tomorrow. And if Judge, could we have it reset for?
Yeah, we'll reset it for next Thursday.
Yes.
Hopefully by then you'll have it lined up.
Thank you, Judge.
Okay.
Mr. Campos, I'll see you next tomorrow. Okay. It's snowing. It's partially snowing today, so today wouldn't be a good day for release either. Okay.
Okay. Thank you.
Thank you, Judge.
Let's speak with Mr. Pignon. Thank you.
Judge, may I be excused?
You may.
Thank you.
All right. Okay, this is cause 2021-0D01550, the state of Texas versus, is it Jahasil Pignon? Is that close?
Yeah, Haciel.
Haciel, okay. Pignon, and that is your true and correct name?
Yes.
And your date of birth is 4/12 of 1987.
Correct.
And you recognize your attorney there, Mr. Lozano?
Oh, hey, yeah.
Okay, and Mr. Lozano, you recognize your client, Mr. Pignon?
I do, Your Honor.
Okay, so if we could, Ms. Espinosa, if you would state the plea agreement on the record.
Yes, Your Honor, it's 2 6 months state jail, and I'm dismissing 2 misdemeanor cases.
6 months state jail. And you're dismissing 2 misdemeanors. What kind?
Criminal mischief.
And he has served at this point.
He has
One-
159 days, Judge.
159?
Yes.
Okay, so that's pretty close to the 180. So you're very close to a release date. Okay, is that your understanding of the plea agreement, Mr. Lozano?
It is, Your Honor.
Okay, is that also your understanding of the plea agreement, Mr. Pignon? Oh, excuse me, I couldn't hear you.
Yes.
Okay, now, you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your plea and we could proceed to a trial on this matter at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your plea. You cannot appeal the case without my consent. And you would begin, I guess, transferred to the state jail at their earliest convenience to serve out whatever remains of this sentence. You understand?
I understand.
Now, we have in front of us some documents marked State's Exhibit 1, the guilty plea and waiver forms in this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, I do.
Did you read them before you signed them?
Yes, I do.
Did you understand what you were reading and signing?
Yes, I do.
Did your attorney further explain to you the meaning of these documents?
Yes.
Do you have any question about their meaning?
No.
So if there's never any question, let me briefly explain to you what they mean. Primarily 2 things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit these offenses. And secondly, you're telling me that you understand you're giving up some valuable rights here today. The most important of those rights, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Understand.
Understanding that, then how do you plead to this charge, guilty or not guilty?
Guilty.
Entering your plea of guilty freely and voluntarily.
Yes.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty? Did anybody promise you anything or persuade you in such a manner that you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon? Now, you understand the potential punishment for this offense, being a state jail felony, is from 6 months to 2 years in the state jail, a fine not to exceed, that would be $5,000. Do you understand I have to sentence you somewhere within those general guidelines?
Yes.
You are a U.S. citizen?
Yes.
And how old are you, sir?
35.
And how far did you go in school?
Some college.
So you can certainly read and write the English language.
Yes.
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
I've been treated.
And for what kind of things, sir? Sorry. Go ahead.
for, I don't know, what is it, bipolar, depression?
Okay. Are you presently under medications for anything like that?
Yes.
Are they helping you? Oh, excuse me, I couldn't hear you. Did you say, are they helping you? Okay. Are they helping you to such a degree that you think you're mentally competent, that you understand everything that's going on here today?
Right.
Okay. And counsel, you've had time to go over the facts and circumstances of these cases, the legal aspects of them, and had time to evaluate your client's mental status?
Yes, Your Honor.
Based on all that, are you representing to me that you believe he is mentally competent to enter these pleas?
He is competent, Your Honor.
And based on your representations, Mr. Lozano, your representations, Mr. Pignon, the court's observations of you in court, both here today and prior occasions, I find that you're competent to enter these pleas. State may summarize the evidence.
Yes, Your Honor, had the state proceeded to trial in this case, the state would have proven beyond a reasonable doubt each and every element in the offense of criminal mischief more than or equal to 2,500, but less than 30,000. As alleged in the indictment, the state moves to introduce state's exhibits 1 through 2, which are the plea papers and the 3914 disclosure form.
No objection.
Receive. Based on the evidence before the court finds the evidence sufficient to find the defendant guilty in both counts, and I so find. I'm ready to proceed upon the issue of punishment. Once you get out of the state jail, what are your plans, sir?
Go back to my home and pursue a job that I could find. I'm finding a job.
Is that a home here in El Paso or somewhere else?
In Anthony, New Mexico.
Okay, back to Anthony, New Mexico. Are you going to live with family or where?
Yes, with family,
Who?
mother and sister.
What kind of work have you done in the past?
Construction.
Okay, well, it seems like there's quite a few of those jobs out there still available.
Definitely.
All right. Do you have any children?
No, sir.
All right. Well, it sounds like you have a good plan. I think the main thing that's a problem is stay on those meds, because if you don't stay on the medications, you'll have another problem like this.
Right.
And that's the critical thing. Being on these type of medications for some of these mental health issues, unfortunately, it's not like having a cold where you just take some medicines and you get better, and then you don't have to take the medicines anymore. These are more like these are more like if you get diabetes or somebody. You know anybody that has diabetes?
No, I don't.
Okay, well, that's like a permanent illness. You got to take medication all the time, so that it doesn't come up and harm you. Well, the same thing here. You've got to take those medications so they don't harm mentally. Okay, and then don't mix the medications, the legal medications, with other things like illegal drugs or alcohol or things like that, because that can affect how the legal drugs are helping you. So hopefully, if you can just do that, I think you'll stay out of trouble. You'll be in good shape, be able to help your mom, your sister, and I think that's kind of probably what you'd like to do, and hopefully you'll get to do that soon. So with that, I will follow the recommendation, 6 months in the state jail, but I will give you credit for all the time that you have served, and good luck to you, sir.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Okay. And now, let's see. Well, let's start doing the bond hearings are next. So, Mr. Lozano, I think you're done. Mr. Pizarro would be the first bond hearing. I'll do that one. I think we already have all of the facts on that case. Okay, so let's see. So I show that you've been in jail about 114 days, and then on this charge. And what is the amount of the bond?
Judge, you beat me to it.
25,000, Judge.
25,000 cash surety.
Yes.
Okay. Now, we did a pretrial conference on this case very recently, February, well, no, pardon me, a year ago, February 9th, 2022. And it appears that this was the date of this offense was around August of 2022. And the police had to go to the hospital where they met the complaining witness who claimed that the defendant was her boyfriend at the time. He had been drinking, he'd gotten into an argument. And he said, well, apparently he shoved her and said he would kill her. And punched her in the nose, and she had some bleeding from her nose.
And I think she broke her nose, Judge.
It was a broken nose.
We spoke with her and it seems like that's what ended up happening.
Okay.
I have the FM, let me look at the FMS records.
That's a pretty hard blow to break the nose. Defendant does have some criminal history. What, did you find what you were looking for?
It's loading, Judge, I'm sorry.
Okay, and then what, okay, we got to get that first, then we got to go back over to the criminal history. Because apparently there's been some problems between the complainant and the defendant in the past, correct?
Definitely a toxic relationship, Judge. I would 100% agree.
Did he ever make bond at all on these cases? Or has he been in jail ever since the incident?
He's been in jail. He has not made bond, Judge, on this most recent one. Been in about 4 months.
Yeah. That's what I shown.
We have the records, Judge, because we have the affidavit, but I don't see them uploaded. I'm gonna have to get them uploaded.
All right. What about criminal history? Go over that with me again.
Look at the rap sheet just to make sure. So he has some juvenile possession of marijuana, criminal mischief, misdemeanor 2020. Then 2022, assault causes bodily injury, AFE, family member. Injury to a child also in 2022. And that was dismissed eventually. And then there was also 2022, a continuous violence against the family, but that was dismissed. So it looks like he's just had everything has been dismissed in the past. This was just like last year though.
Okay. Have you spoken to the complainant recently?
Yes, we have.
What information do you have that would be, I guess, pertinent to this bond hearing?
This was February 10th of 2023. That's when she notified us that her nose had been broken and that he had assaulted her on different occasions. However, well, she still wanted to go forward with the charge.
Okay. Did you have a recommendation in this case yet?
Yes, Your Honor, I recommended 3 years deferred probation.
Is she aware of that?
I believe so. I think
All right.
obviously it would be with no contact.
What information do you have, Mr. Morales? Anything else about the defendant? Where would he be staying? What would he be doing? What kind of bond can he make?
And Judge, I've actually been in pretty frequent contact with Ms. Pizarro, the defendant's mother, as recently as this afternoon. I actually spoke to her just, excuse me, a little while ago. And Judge, I think you nailed it on the head. I mean, this is the clearly a toxic relationship. And Evelyn, I had mentioned before that I had some video of the complaining witness assaulting the defendant. And it's allegedly here in our Odyssey system. I'm looking at the note from our investigator. I got to figure out a way to get that over to you, but the recommendation is still something that Mr. Pizarro is going to have to think about. Judge, we've got him available to move back in with his parents at 16220 La Vina here in El Paso, Texas. So we got a place for him to go. The good thing is that the two of them, these young people, they don't have any children together. They're not married. There's never been any stronger advice or any stronger persuasion that the two of them should stay apart, that he's been in jail the last 4 months. I'm sure Evelyn's looked it over, and there are some troubling pictures here. I have to concede that, but in the video, not our video, not even the one that I want to provide to Evelyn, but in the video that's in the state's possession, you can see the complaining witness repeatedly strike the defendant in the video, and that she went to his house that day. It just seems to me that these are two young people that need to stay as far away from each other as possible. And if they can do that, maybe they can start to put their lives back together. If there's going to be a probation rec, Judge, we would hope that there's a deferred rec out there on the felony charge. I think Evelyn, you made that in February, so a couple of weeks ago.
Mhm.
I did see that. I'm hoping to get him out on bond, another dress rehearsal for this probation, so that he can assist me in the preparation for the defense on this case, and to go over it with me, to look at the evidence and look at all the, because I guess there's multiple videos of the two of them kind of going after each other, and really take our time in preparing for the defense of this case. It would be useful for me to have Mr. Pizarro out, Judge. Some of those time date stamps are not always accurate on the videos, and I want him to sit down with me. Hey, when did this take place? What happened before this video started? What happened after this little video clip ends? I really think that he would be instrumental in assisting me in the prepare for this case, Judge. So, and the mother, and like I said, you can't emphasize with Mr. Pizarro that he should stay away from the complaining witness more than by him being in jail for 113 days. So he knows to steer clear of her. I need his help. I can get him in with his mother. No kids, not married to her. I think they're finally done with each other, Judge. I hope they are. And if they're not, he's got to only blame himself. I was talking to his mother today, Mr. Pizarro, and I spoke to her. I'll tell you, I saw the video. She shows up. Don't go out there. She shows up to your house. Call the police.
Yes, sir.
Excuses. So we're hoping we can get him out, Judge. Looks like the family could probably make a $5,000 corporate surety based on the 10%. So that's where we are, Judge.
Thank you, sir.
All right. What I might want to do is, like you said, we have both of these young people, it might not be a bad idea to have an in-person hearing with both of them in court. Like early next week, like on Tuesday. And you said the mother will be able to come, probably. And
My client's mother will be able to come.
yes, that's what I mean.
Complaining witness,
Let's see, I would like to see if maybe you can get the complaining witness to come down too, if she can, I guess if she can.
Well, Judge, I mean, in this situation, she actually wants to go forward. I don't think it's a good idea to have them in the same.
Oh, I was just, but to make sure that they stay away from each other. That's the only thing. I
I'll
wanna-
notify her to stay away from him, but he also, I think the one here
Yes.
that needs to stay away is the defendant.
Yes.
I will call her
I just-
personally to let her know, but I just don't know. This isn't
What,
like.
what are your
It's all-
feelings? Do you feel the $5,000 cash surety and PR is sufficient with a no contact and?
Your Honor, well, I mean, I feel like at the end of the day, you know, yes, there may be like a toxic relationship, but at the end of the day, the allegation is that he punched her in the face. She went to the
Right.
hospital. She
Oh, I
broke
know.
her nose, and I agree that there should be no contact. She says that she's still somewhat afraid of him. I think the biggest thing is for them to stay away from each other. Judge, then the other concern is that, the prior charges that he had were not against, one of them was against the same complaining witness, the other one was against his own sister, his own family. That was a continuous violence and the injury to child, elderly, or disabled. And so I think that Mr. Pizarro might have anger issues. And so I'm gonna leave it in your discretion, Judge, but I think that he needs to be admonished that if he picks up another charge, it's not gonna be deferred probation. The recommendation will not be deferred.
and
Well,
just so Mr. Pizarro, Judge, just so he understands that, if you get out on bond and you pick up another charge, the recommendation will be TDC time.
Yes, sir.
Right. It's
Because the
prison.
charges, Judge, one of them was February 27th of last year, and then the second one was April 18th of last year. And then now we have this third one, August 18th of 2022. And so
Right.
it's like a continuous pattern.
all right. Now you understand, Mr. Pizarro, I guess I'm gonna go ahead because the recommendation is that, I mean, if you pled to this offense, you'd be out anyway, you know?
Yes, sir.
So, I mean, the main thing is the most important condition in this PR bond or portion of it, I'll go with the 5,000 cash surety, 20,000 PR, but that there be no contact at all. Not in writing, not texting, not phone calling, not going by. And Ms. Espinosa, you might, you can recommend to the complainant if she wants to get a video camera at the house or something, that she can have one down there. And if she shows that he's comes up there even to, be within a few hundred feet of, don't even go over there.
Sir, and if she comes to my house, do we have cameras? Do I,
Well, you have cameras too, right? You already have them because we obviously know you do. Like your attorney said what did he tell you? Don't go outside. Don't confront her. Don't answer. Call the police, tell them there's issues and maybe they'll come out and maybe they won't. If you happen to by chance run into her you're out at Cielo Vista Mall or somewhere and you see her, just back away and leave the mall.
Yes, sir.
Or if you're in a restaurant and she walks in, leave the restaurant, just, you step away because you're the one that has the charge.
Yes,
Okay.
sir.
You understand?
I
Don't want any more problems on this.
Yes, sir.
Okay, because like if it happens, there are two things would happen. I'd revoke the bond that puts you back in jail. And number two, they'd revoke this probation and they would see prison time. You understand?
I understand that, sir.
Okay. So
And if I can add, Judge, to Mr. Pizarro, the solution to this problem, if she shows up, is not the two of you trying to record each other doing things to each other. You gotta stay away from it. 100%. Absolutely. No anything, no ifs, ands, or buts. You don't have any kids, stay away from it.
Yes, sir.
all right. So, is there anything else, Ms. Espinosa, that you think we need to have on the bond?
No, Your Honor.
Okay. All right. Thank you. Then let's do the next one, which is Mr. Haywood. And then I've got, like I said, Mr. Morales, I've got a couple of your statuses for tomorrow. We can do those when we get done here.
That'd be great, Judge. Thank you.
Oh, yeah, we've still got a fair amount of time. All right, let's go on to the case with, and thank you, Mr. Visato.
Thank you, Judge.
You understand the court is very serious here.
Yes, sir.
Okay, thank you.
Thank you,
Okay.
Mr. Morales. Thank you, District Attorney. They were
Okay, let's talk now with Mr. Haywood. Now, this case, I didn't have any of the facts. I don't have any facts. I don't have any criminal history. I don't have any, because we never even pre-trialed this case. It must be fairly new.
Yes, Judge, I can give you, well, the alleged.
Let's see, it's in terms of, well, it's a 2022, a late 2022 indictment. Well, he's only been in jail 14 days. Okay, so that may be the reason I don't have too much yet. Okay, bond hearing. And let's say, well, it's been 15 days now. And what is the amount of the bond on Mr. Haywood?
It's 80,000 split, so it's 75,000 surety, 5,000 PR.
75,000 cash surety, 5,000 PR.
Yes, Judge.
All right.
And Guadalupe, could you tell if that's on, because there are like different counts. Could you see what the bond is on
Which
each
one is
count?
Okay,
Is
let me,
that the total amount of bond?
I
or
believe so. Let me double check.
Does that sound right to you, Ms. Pettis?
That's correct, Your Honor.
Okay, well, she's checking that. Ms. Espinosa, you can give me the alleged facts here.
Yes, Your Honor, and I only asked because there are two victims in this case. And I believe that the bond is only on one count and not on both the injured parties.
Yeah, I'm only seeing, it has it listed for count 1.
Okay,
And he does have a military hold.
A
Right.
military, in other words, the
Yes,
U.S. military wants to put him in like a military stockade. Is that their?
I don't know, Judge. It just says that it has got a military hold.
Okay. Okay. Okay, well, go through the alleged facts with me first.
yes, Your Honor, this on June 5th of 2020.
2020?
Yes.
Okay, that's quite a while back. What happened?
Police were called to UMC, the ER, regarding a 3-month-old infant twin. She was taken in for vomiting and seizing, like seizures. And they found that she had a bilateral subdural hematoma, sorry, broken left tibia in the healing stages, and retinal hemorrhaging in the left eye.
So there was brain bleed, there was broken leg, and
Yeah.
and you said what was the final one? There was
Retinal
oh,
hemorrhaging.
okay.
So like
Eye.
yeah, like a spot in her eye.
And this
And
3-month
they,
old.
right, which they felt was consistent with child abuse. CPS later basically made the defendant take the other twin because they're the same age to UMC for examination, and they found initially she had 3 rib fractures. Dr. Stern, I guess this was at UMC, found that that was indicative of child abuse. So they admitted her to the Children's Hospital where Dr. Ross evaluated her. And they found over 20 rib fractures in different states of healing. They were more than 10 days old, but less than 3 months old. Or I guess they varied.
between what, 10 days and what?
3 months. And Dr. Ross determined that that was indicative of child abuse. The defendant and his wife gave a statement basically saying, he said that he didn't have a lot of time with the infant child because of work, and that when he would get home that he was tired, but he would try to relieve his wife. He said he doesn't know how the child obtained, or the children obtained the injuries. Even though he did say that, and they both agreed that they were the only two individuals that would care for the children. And so I think our office has been in communication with both, the children now, Judge, are with his parents, his father and his stepmother.
Children were with his parents?
His
Where are
father.
they at?
I'm not sure where.
Are they out of state?
I think so, Judge. We made contact with them recently. But his dad made the comment that he thought that the defendant should be in jail because of the injuries to the kids. And I believe we've been in contact with the mother. She was not charged because after investigation, it is suspected that she was also a victim of domestic violence in this situation. And the defendant does not have any other criminal history.
And he was in the, okay. Did this occur on the injuries occur on post or off post, or allegedly? Would they have an apartment off post? Do we know? Is that why the U.S. Army has a hold? That they think they have a case that occurred within their jurisdiction, or what?
That might be the case, Judge. I know that we have been in contact with, I think it's his like sergeant or someone. I'm not sure what they're gonna do.
Well, apparently they didn't arrest him until just very recently.
Well, no, I think what happened, Judge, is he was actually, from what I understand, because there was a CPS case involved, and they deployed him to Korea, or he was in Korea for about a year, and then he came back, and when he came back is when they arrested him.
And Your Honor, if I may interject.
Yes, well, because you maybe have some information here.
Correct. So first of all, clarification with regards to the injuries. Based on my review of the police report with regards to the fractures, it's not more than 20, it's less than 20. The doctor clearly states that.
I said more than 12, less than 20.
Less than 20.
Yeah, I said more than 12 though, yeah. More than 12, sorry, I don't know if I'm
less than 20.
Pronouncing it, yeah.
And initially, Your Honor, I think this case is a little bit complicated. I myself have reached out to his former platoon sergeant. I spoke to her yesterday. And I guess if Evelyn can look at the report where it says initially when Judge Ayun was the first judge who reviewed, I guess, a PC on this case and had issued the arrest warrants. When my client was arrested along with his wife at that time, she was also arrested, was February 10th of 2021. These allegations, the time period that they're alleging that these injuries occurred were between March of 2020 and May of 2020. My client was initially arrested, but then not booked because when he went before Judge Acosta canceled the warrants. And I'm assuming probably based on the fact that there was no PC there, sufficient for my client to be arrested. Time goes by. The state does not indict the case until December of 2022. The warrant isn't issued until January of 2023. CID makes contact, and I verified this with his platoon sergeant, yesterday, First Class Sergeant Siegel, they kind of made sure that there was no hold because they knew that there was this pending, possible investigation, possible charges. Nothing, was pending with CID. They cleared him. They signed off on his official transfer orders to go to Georgia because they felt that it was in his best interest because of the fact that I think there's some type of animosity between the father, which is the grandfather of the twins, and with regards to my client, because even the sergeant verified yesterday, there was numerous attempts because CPS did remove the children from the custody of my client and his wife. The grandparents were granted sole managing conservatorship, which is grandfather paternal side, and the stepmom, and my client and his wife were given visitation rights. However, visitation rights have not been able to be exercised by my client because the grandfather of the complaint of the two CWs will not allow them to visit with the kids.
Where are the children? Are they in Texas or somewhere else?
I cannot tell you whether or not they are in Texas or they've relocated. And unfortunately, neither can my client because the grandfather does not allow him to see the children. And even in the report, if Ms. Espinosa looks at the report, whenever they made contact, whenever EPPD made contact with the paternal grandfather, his whole concern was like, oh, well, he's not paying child support. That was like his whole main concern because my client was ordered to pay child support whenever the children were removed and paternal grandfather and stepmom were given sole primary custody of the two twins. So my client has not been able to see the twins, is my understanding, since they were 9 months old.
How old are they now?
They are 2 years old, if I'm not mistaken. Is that correct, Mr. Haywood?
I'm about to be 3 on the 6th.
Okay, about to be 3 on the 6th. So I think there's going to be some issues, and also with regards to whenever they did interview my client and the wife, who now, I guess just based, I'm assuming that the DA is now saying that there's not sufficient evidence to possibly indict her is because of the allegations that were made by the neighbors, because that's the only information I think any of us have with regards to what the neighbor said, that, they heard at some time, which is all, pretty much hearsay because they weren't even present. But I think that's kind of like where the DA is now saying that, it could not possibly, the injuries could not have possibly been the result of the wife. Not sure who, how the injuries were sustained. I'm assuming there was issues also whenever Judge Acosta, they went before him and he canceled the warrant and they were released. So I think
He did do a tour in Korea. He did go to Korea.
Where's Mr. Haywood from?
He was born in Ohio, Your Honor. But he has been here. He's been in the military for 6 years. He joined October 2026. So he had been in Fort Bliss prior to his transfer to Fort Stewart in Georgia. And that transfer was, I believe, the 13th of January.
So when did he go in the military? How long has he been in the military?
For 6 years, Your Honor.
What's his rank?
He's a specialist.
Specialist what? SP what?
Mr. Haywood, could you answer that for the judge?
SPC. So it's just an E for just SPC.
SPC.
Okay. Where do you consider home, Mr. Haywood?
Ohio with my mom and her mom.
Okay. What part of Ohio?
Portsmouth.
What kind of bond can your client make?
Your Honor, the only funds that they have available right now is $1,000. That's all he has. I mean, he was extradited from Georgia. Whenever he got to Georgia, that's when, as I indicated, the warrant was not issued until January of this year.
Did you have any information about the location of where the injuries could have occurred I guess, in their apartment. Was that apartment located on Fort Bliss, or was it located in the city of El Paso? Where was it?
It was in the city of El Paso. I don't have information whether or not it is inside Port Bliss. I don't know if ADA Espinosa has that information.
Do you know why there is a military hold? They don't usually do that.
I don't, Your Honor. I did ask his former Sergeant Siegel, yesterday when I spoke to her. She did not have information with regards to that. She was not even aware that there is a military hold. She did direct me to a Captain Boykin, so I will call him to inquire as to, what the purpose, or if he knows, if he's able to release that information.
So if he were released on some form of a bond, where would he go live?
So right now, Your Honor, given the fact that they've recently just relocated, I mean, his wife is in Georgia. He would be going right now to a homeless shelter, which would be the rescue mission. I know he mentioned that he does have a pastor that may be willing to house him during the interim until, they decide whether or not his wife is going to come back, because, this case is pending.
Are he and his wife still married, still together?
Yes, Your Honor, they are. So I'm trying to get a contact number for his pastor, Matthew Mitchell. But my only point of contact would be the wife. And given the fact that, the wife may not be involved, not sure, because she is named in the, report as offender 1. I really don't want to have much interaction with her, possibly if there's any charges coming down.
All right. So you want me to set the bond at like 1,000 cash or surety and some form of PR?
Yes, Your Honor. Given the fact that this case is old, it's from 2020. The initial arrest warrant was canceled by Judge Acosta. Just in my review of the case, I mean, there's indication in there that the mother of the children, she herself made an admission that she had postpartum. That was indicated in the police report. She made the police aware of that. And given the fact that, it's unclear where these injuries, I think the state is going to have a difficult time proving how these injuries were sustained. Just in my limited review of the police report, these injuries were old. They were, 2 to 3 weeks or even more, but no more than 3 months, because of course the children were 3 months at that time. My understanding is that the children were also premature. But at this time, I would ask that the bond be lowered to 1,000 and the rest be PR.
Okay, your position, Ms. Espinosa?
Judge, I mean, we're obviously opposed, considering the injuries to the 2 little girls. And also it doesn't sound like, 1, he's not going to get out of jail either way because of the hold, and 2, there really are no contacts here in El Paso. I would be concerned that he's probably going to try to leave. He doesn't have any other family here.
Well, I'm kind of interested. No, I'm at this point, I'm going to deny it, because I think I can't go that low. That's just on a case like this. The allegations are too serious. But I mean, if the military has some plan, I'd certainly like to know what they're doing. I mean, if they want to take custody of him, that makes a big difference, And I don't know if they want to put him if they want to, put him in camp and, in Georgia, or if they want to put him in the stockade. I don't know what they mean by all of this. So they've not made any attempt to remove him from the Army at this point, to your knowledge, Ms. Pettis?
No, Your Honor. Based on my conversation with his former platoon sergeant, they have not.
Well, at this point, I'll deny it, but I'm concerned about, very, very minimal contacts with this community. Also the serious nature of the allegation. But then again, you have brought up some points as to, how is the state going to prove this? You've got injuries that occur. They must have occurred in the custody of one or both of these mother or father. So have you interviewed the mother of the child, Ms. Espinosa?
No, Judge, I haven't.
Because I don't know.
I
You all
think
made,
someone in
you
our
all made a
office-
you all made a decision not to charge her. Was this case handled by Ms. Clausen or somebody like that?
Yes, someone from the RCA unit
Yeah, it
has
might
been
be.
working it up.
Yeah, it might be good to confer with them too. And I can review this thing later, but I'm still, even though I've gotten some facts, I'm missing a lot of facts. What's going on here to satisfy the court for a bail reduction. So with that, it is denied, but I want to get back and get some more information on this case fairly soon. Okay, thank you.
Okay, Judge.
And Your Honor, just for the record and for the court's, I guess, notice, Mr. Christopher Hernandez will be taking over the case. So he will
Okay,
lead counsel of the case.
it won't be you. It'll be Chris.
It will be Chris Hernandez, just basically based on the severity of the allegations, it'll be transferred to our complex litigation unit, and he will be an attorney.
Okay, well, that makes sense because it is a complex case. All right, thank you very much.
Your Honor, may I be excused?